Honorable, the Supreme Court.
Almost said good morning, everybody, but good afternoon. Nice to see you. Please be seated. Before you call the case, let me just say this. I understand we've got wasps in here. I know I've had an allergic reaction to ones, and there are probably others here who have had allergies of one kind or another. If this becomes a problem during the hearing for anybody, just take off. I don't want, we're not gonna subject you to physical pain and injury. And we'll figure out, we're just talking in the conference room about maybe actually adjourning this right now to virtual, but in order for the lawyers to be virtual, you'd have to stay in here because this is the only floor. We don't have computers here. So we'll go ahead with the hearing, and if it becomes a problem, just say so, and we'll take a break and make sure that everybody's safe and not subject to the venom of a hornet. Although I think they're pretty slow moving these days. It's the end of the season. Okay, yeah. Reminds me of the time I was in Addison County and Silvio Poleni said, well, you can take your jacket off. It's so hot in here. This is a slightly different problem than he. Yeah, I love Silvio. He's a great guy. Okay, please call the case.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled In Re Ranney Dairy Farm, LLC, Major Subdivision Appeal, Westminster DRB Permit Number 21-70. Case number 24-8P009. Representing the appellants, Daniel Dietz et al., is Fletcher Proctor. Representing the appellee, Ranney Dairy Farm, LLC, is Sam Angel.
Okay, thanks very much. Counsel, come on up if you would, please. And for the record, if you'd introduce yourself and identify your client and then proceed.
Thank you. Chief Justice, Associate Justice, good afternoon. My name is Fletcher Proctor. I represent the appellants who are Daniel Dietz. I have to get the whole list on the computer.
Well, that's all right. You don't have to, unless you want to, you don't have to recite all of them.
Daniel Dietz, I guess they got rearranged alphabetically. Victoria Gulas, Stephen Gulas, Teresa Sylvester, Michael Sylvester, Daniel Dietz, Martha Moskov, and Nancy Pike.
Thank you.
May it please the court. The matter before the court is the appeal of a permit granted to the appellee Ranney Dairy Farm LLC for subdivision of its property located on Old Cotting Road in Westminster. Old Cotting Road is a private road. The appellants all own property along Old Cotting Road. Most of these properties are their homes, and Old Cotting Road provides their only access to them. All of the appellants hold deeded rights of way over Old Cotting Road. Although the Ranney Dairy Farm property as a whole has frontage on 3 public roads, as proposed by the appellee, access to the portion of the property being developed lies over Old Cotting Road.
Well, if I could, I don't mean to interrupt you so soon, but you say access to the property is over Old Cotting. Doesn't the record reflect that it's short by 400 feet?
That's a very confusing point that I did not draw out well in my examination of the appellee's.
Is the point of is the 400 contested fact?
There's one document that actually the town of Westminster identified as the document laying out Old Cotting Road. I don't believe it does anything of the kind, but in its most generous interpretation, it's only 411 feet long, whatever is described in that document. It is in the printed case.
The road is 411 feet.
Whatever is described by that document Old Cotting Road is actually about a mile long total.
Well, I was getting at the fact that the road itself is short of the property that's in question here. Is that true?
Well, it depends on what you think about that document. If you think that document is part of Old Cotting Road, it's certainly short. I think that document really doesn't relate to Old Cotting Road at all, but be that as it may, the most generous interpretation is that it describes 400 feet of a mile-long road.
I see. Okay.
And to be fair to the applicant, the mile long is beyond their property. They have to the back end of their property is about 3,000 feet. But anyway, you slice it way beyond 400 feet.
So when you say it's a private road and there's right-of-ways or easements that are granted for ingress and egress, who granted those?
The people who originally subdivided it, the Ranneys settled that whole area, and another branch of the Ranney family owned the property south of Old Cotting Road, and they subdivided. The subdividers very quickly realized they needed rights of way and started either when they subdivided and sold properties, they granted it with rights of way. In a few instances, title searchers discovered the lack of a right of way and went back and got right of ways to correct the lack of them.
But there are folks involved in this case that do not have deeded rights of way. Is that right?
There is one property owner out Old Cotting Road goes along and makes a dog leg just north of the town line. At the point of that dog leg, there's a landowner whose property is actually described in his deed as being on a road in Town Farm Road in Putney, which comes up the back side of the hill. But he has been using Old Cotting Road as an access. In our opinion, he's a trespasser. At some point, my clients may want to deal with it. But he also he has access to south through Putney.
This is a question raised in part by your opening, which is, do I understand you to say that this is not the only access to these properties? It's the preferred access, but not the only.
Only if you want to trespass over Terry Ralston's land. He is not particularly welcoming about that. In fact, he's prone to putting large rocks across the road. Because once that road takes that dog lane, the extension of it that people had created is really on his land. He doesn't like people charging through there.
Okay, but I'm missing exactly any kind of map of the circumstance. I thought you said originally that to the properties for which the development is sought, there are methods of getting there through the property that's owned by whatever Ranney Dairy Farm.
Ranney Dairy
That they didn't take. Instead, they took this because it was the most convenient. Is that?
Yes, and unquestionably the least expensive way to do it. But they also have, as I said.
So here's why I'm asking you this question. This question of what happens after a road is discontinued to the people who used it is now governed by a statute. You cited to the cases that picked it up from the common law, but not the statute. The statute requires that it be the sole method of access in order to have that right over the old discontinued road. You're telling me there are other methods of access, if I understand.
For Ranney Dairy Farm, they have frontage on 3 other public roads.
Yeah.
If the discontinuance of Old Cotting Road was in 1893, so well before the statute.
So does that mean the statute is not here? The statute was done, I think, in 2005.
What's the section, John? What is it?
19 VSA 717C. And I'll read it so you understand the question. A person whose sole means of access to a parcel of land or a portion thereof owned by that person is by way of a town highway or unidentified corridor that is subsequently discontinued shall retain a private right of way over the former town highway or unidentified corridor for any necessary access to the parcel or portion thereof and maintenance of his or her right of way. So the statute seems to be narrower than what the common law was. So I guess I'm asking you out of the blue, what's your position on that?
Ranney Dairy Farm LLC has other routes of access. They are not landlocked. My clients have only one route of access, and that's the road, Old Cotting Road.
Of course, one of the other questions the statute raised is what is an unidentified corridor?
Frankly, that's a dispute I have with the town manager in Westminster. He liked to use that phraseology because it sort of got him through the ancient roads controversy. But Old Cotting Road has never been unidentified. Maybe out where the bridge fell through, it's become unidentified, but it's never been an unidentified corridor. The town manager liked to use that to try and get around ancient roads. And as I was an elected official in the town, I used to dispute it with him.
One other question is the standard that was used by the environmental court was creation of a threshold in interest. Where did that come from? I can't find that really in the Supreme Court cases. Is that something that got created in the environmental court?
There is a case, Claremont Terrace, in the environmental court, and that speaks of threshold inquiry, but it's only speaking of the applicant's obligation to show that they either have ownership or control of the land they're seeking to develop. It doesn't, I personally don't, well, I will argue that they do not, it doesn't apply to the access part, because access is actually driven by another statute, 24 VSA 4412 sub 3, that requires that there be a permanent easement or right of way, and that it be, the statute says that it be at least 20 feet in width. And it required, that statute is actually mandatory on the towns. They have to put that into their subdivision regulations. In Westminster, they chose to actually change that standard. They have a minimum 50-foot wide right of way. But
so what do you want this court to hold? That there is no such thing as a threshold interest test?
I believe for this issue, there is not. I mean, the environmental court may be entitled to some respect on their decision in Claremont Terrace, but as to access, I don't see how, I mean, it felt almost as if you walked into the environmental court with a paper napkin and said, this is my access, and that would be sufficient.
You know, this issue of threshold showing, doesn't that effectively change the burden of proof?
It felt that way to me. I mean, it lowers the bar so far down on the applicant that it shifted the burden to us to an impossible task to prove that the non-existence.
And why is it that the environmental court does not have jurisdiction to make this decision with respect to what the statute requires, which is, and I'm talking about 4412, which says that projects are not okay that do not have frontage on a public road unless there's a permanent easement or right of way. That's the express language of the statute. How is it that the trial court could be right in deciding, I know it cites other e-court decisions, but what's your position about their jurisdiction to make the decision with respect to, as the statute says, whether or not there's a permanent easement or right of way?
4412 is in chapter 13 of title 24.
Right.
The environmental court enabling legislation specifically gives it jurisdiction over any issue that arises out of chapter 117.
Yeah.
I absolutely believe they have. I think the judge's dilemma, Judge Walsh's dilemma, was that he didn't want to be in a position of deciding between competing claims to property rights. We can quibble over what an easement is in terms of property rights. It's not ownership of the fee, but
But
even,
it's a property right, isn't it? I mean,
even giving him that, it's still, we're not talking about competing claims. We're talking about, do you have access, don't you?
Yeah.
Can you demonstrate that you have something that grants you the right to go across that road? And nothing was forthcoming. And the real problem then becomes, the other thing that wasn't forthcoming was anything demonstrating that that road had ever been laid out. There is nothing in the record that shows it. The thing that they put in, that 400 feet thing, it's, if you look at it, it's in the printed case. It titles itself a receipt, a surveyor, a receipt for surveillance services. But, you know, at that point, we were under, you know, at the time that that was laid out, I think we were under the same era that's addressed in Austin versus Middlesex. And there's a three-part requirement for laying out a road. All that's been suggested is, and it was suggested by the town, is one document that doesn't come even close. So right now, there is nothing in this record that shows that road was ever laid out.
I know you're unhappy about the town being in the case in the way that they were, but didn't that give you the opportunity to get discovery from town as to what they have for records that make?
Oh, trust me, what is it? Herbert Younger said, I'm wasting the flower of my youth researching that. I've spent days on end in the land records. I believe Mr. Angel's surveyor has been in the land records. He's been in the county records. And there is a former lister in Westminster who has by hand transcribed all the early records of the town of Westminster to make them searchable. And I've spent an afternoon with her. We can't find a darn thing. The surveyor's father did all the ancient roads work in Westminster. He's the source reference to that document that I say doesn't, the 400-foot document. And when you look at it, it doesn't measure up.
What you couldn't find doesn't get in the record for this case. I was thinking maybe you should have got someone to say that, what you're now telling us, in a way that could become evidence for the case.
I will tell you, Your Honor, it is not easy to direct surveyors into court these days. I mean, the surveyor that Mr. Angel enlisted is the guy who pretty much covers Westminster, and all my other resources have retired.
So, Mr. Proctor, are you saying the environmental court was wrong in its findings when it found that in 1833, the 1833 record laid out Old Cotton Road?
Yes, absolutely unequivocally that finding is without support. It's not the only thing I would quibble with, but that certainly. I mean, you can look at the document case that is referred to as the 1833 document. It's in the printed case.
Okay, your time has expired. Thank you very much.
Thank you, Your Honor.
We'll hear from counsel for the appellee, please. Come on up.
Thank you, Your Honor. Your Justices. Good afternoon.
Good afternoon. Please introduce yourself and identify your client for the record.
Thank you. My name is Sam Angel. I'm an attorney in Brattleboro, and I represent the appellee applicant, Ranney Dairy Farm LLC, a sole member LLC.
Thanks.
You're welcome. Good afternoon. It's nice to see you all in person. First of all, I'd like to say that the appellant's argument that the court had jurisdiction to determine the property rights of individuals and their argument that the threshold burden should go all the way back to finding out whether or not the town road was actually laid out are just two bridges that are too far. It's not what the Supreme Court has said, this court, and it's not what the Environmental Division has said. Justice Reiber, to answer, I believe it was your question about where did this notion of a threshold I think it's a very interesting discussion to have about the threshold question, but certainly I don't believe, I just want to get rid of the jurisdictional bit for a second, because the more interesting thing is the threshold. The jurisdiction continually of the environmental division has not been to examine recorded documents and determine what rights those documents hold for individual litigants and property owners.
Yeah, but counsel, this statute is so clear and so specific as to projects that do not have frontage on a public road unless there's a permanent easement or right of way. How is it, that we could manage a court system where parties have got to go back and forth between different judges and different dockets in order to resolve issues that clearly are combined in one manner?
Well, Your Honor, first of all, I believe that they do have a permanent easement. That permanent easement essentially is granted by common law, specifically in the Okemo case, because of the fact that the road was discontinued. There's no question that the appellee and the applicant had frontage on the road at the time of the discontinuance, and therefore retains right of access to all or a portion of their land.
But we've got all we have is a decision by a trial judge that says a threshold showing has been made. Threshold showing is not a decision that there's a permanent easement or right of way.
Well, a threshold showing, I thank you for getting to that, because I also wanted to get to where that case was.
Yeah.
It was Judge Durkin's decision.
Yeah.
And let me just see if I have it here in the later. Excuse me.
No, that's all right, Judge.
In later subdivision permit, it's docket 85-4-07. And in that decision regarding threshold, the burden and the limits of jurisdiction, Judge Durkin indicated, and I'll just read from the decision.
Sure.
Right, I think that might seem to say it pretty well.
You're saying lighter, Lighther?
You know what, actually, I'm gonna refer you to Lancaster, which is another environmental court decision that cites to lighter, but that's got the better language. The Lancaster decision is.
And whose is this? I'm sorry, counsel, but.
Again, this is Judge Durkin.
Durkin, okay.
Yep. And that's docket number 1-1-14 VTEC. And what he says is, we have recognized, however, and this is on page 8, that we have the authority and duty to determine whether an applicant has made a sufficient threshold showing of lawful interest and right to develop the subject property as proposed, e.g. in Ray Lighter subdivision permit. That's the one that I was just citing before.
Yeah.
Once this, quote, initial threshold burden, end quote, has been met, any disputes concerning the ownership and control of the real property at issue must go to the appropriate division of the Superior Court, the civil division, which is all in charge with determining, through things like declaratory judgment actions and so forth, the rights of individual property owners. The threshold burden.
So how can you not get around who owns Cotting Road, or that someone does own Cotting Road, or who controls Cotting Road, or?
Oh, I don't have to get around it, Justice Cohen. What happens when the road is discontinued is the abutters along the road onto the center line of the road. But the access, it's a private right of access that remains to all of those who abutted the road at the time it was discontinued. So the ownership is not in question, but perhaps I misperceived your question.
No. I'm just trying to figure out, it seems like there was some joint effort between everyone for road maintenance, for fixing the road, for taking care of it, for doing all the things that are necessary as part of a private road without any specific agreement. It's like
There was
a shared driveway.
It's on the road that was done, and there were also rights of way that were granted by the appellees to each other that came about because one of the appellees, Victoria Goulas, was refinancing her property. And the bank required her to get written rights of way in order to do the refinance. And that's how those came about. Those didn't come about through needing necessary access to this property. The access was obtained at the time that the road was discontinued. The initial threshold burden, actually in this case, I mean, I want a threshold burden with all due respect, Justin.
No, it's okay.
The threshold burden if you were to follow what the appellants are arguing, it would require all permit applicants that had access via a discontinued town road to try to go back all the way, not through the land records, but a lot of those early things are actually housed in the Vermont Superior Court in the center of the county in which those courts reside, the performance records. They're incredibly difficult to read, and creating something like that would create essentially chaos in the permitting process. What my client showed, rightfully, I believe, with all due respect, is that we showed the chain of title going back to when the road was discontinued, prior to that actually, that they abutted the property, that the road was discontinued by the town, and therefore they had access by common law, not necessarily by statute, as Justice Reiber has asked a couple of times. That statute was enacted afterwards. My clients, so that's, if there's like a landlocked parcel or something, then maybe that statute might apply.
So just so I understand your position with respect to the statute, your view is that no statute that was not in effect, to and negative, so.
Yes, Justice.
Statute not in effect at the time of the discontinuance of the road is irrelevant.
True.
So even though a new purchaser comes along, even though it's a totally new development, that statute is, it seems like then the statute was of no consequence when it was enacted.
It would have been, there would have been consequence to some individuals, but just not to my clients. And in fact, another interesting thing is that one of them was the lead appellant at one point, obtained a parcel of property that was wholly owned by my client. And when they obtained that property, my client gave them an easement to Old Cotting Road. They then used Old Cotting Road as access to the public road, McKinnon Road, which accesses Westminster Westwood, for 18 years as a residence, under the same title that my client, and under the very same facts and circumstances. So it's a little bit absurd, and to create a situation, in my view, would be to create quite a level of chaos, if you will, among the permitting process. In this particular case, the town actually declared that the road was a discontinued road. Not all towns have done that, but that's another thing in terms of a threshold burden. Well, maybe a threshold burden is, an applicant showing that the town has made a determination about the status of a road. We did that. We showed that we had the title interest. But to have an applicant go all the way back to see if a road is properly laid out, first of all, is not something the environmental division or this court has ever considered.
But you would say that that is not the applicant's burden. It rather is the burden of the neighbors who are contesting the application.
What I would say, Your Honor, about that is that once the applicants have met the threshold burden, first of all, that's it. After that,
So it's not just a threshold burden, it actually is the whole ball of wax.
Well, whatever burden that is, it's been called the threshold burden by the environmental division. But once they have shown that they have a legally cognizable interest to develop the property, in this case through an access that was obtained through a discontinuance, then they don't need to show more. The burden doesn't then shift to the neighbors, if you will.
Yeah.
It would have to go to the civil division if they wanted to get a declaratory judgment as to the actual legal rights, and they could make whatever arguments they want there. Even if the burden was to shift, Your Honors, if they were to hold that once an applicant has made some type of a, let's just call it threshold burden, since the environmental division has called it that, even if it were to shift then to the neighbors, they never provided any evidence that it wasn't laid out properly. For example, they could get their own title exam. They could get a surveyor. They could get anybody they wanted that had, as long as they met the Daubert challenge, I suppose, but if they were certified and they were, if they were the proper person to be able to examine the land records, it could say, I've looked where all these things should be and they weren't there and the road was never laid out. Well, that might have been something, but they did not. They did none of that. They didn't do that. There was no burden shifting. They even themselves thought, that once the threshold burden was met, that was it.
All right, so what happens when the neighbors decide they are gonna go to the civil division to flesh out this issue of the road? What happens to your project?
Well, first of all,
Motion to stay?
I don't think a stay should be issued, but I do think, Justice Eden, that is what should have happened if they truly believed in their argument. They should have immediately stayed the civil division action and filed a declaration, a declaratory judgment action in the civil division in order to determine what in fact was the situation. The town has said the road was laid out. The town has come out in, let me just see, I have the site for the declaration in 2017. It's AV1, that's the discontinuance, I'm sorry. I don't seem to have it right here. I can get it if you want, but the town actually went through the process of actually declaring what the legal status of the road was. So in that case, there's no question that I think, in my humble belief, that all applicants should be able to rely on a declaration of the town as to what the status of their access is. If they can't rely on the town when applying for a town permit, I don't understand what the acts of the town would even mean at that. What would it matter if the select board
We
said,
don't have anything that shows what the town did to come to any kind of conclusion about whether the road was properly laid out in the first place.
well, they call it a town road in they call it a highway actually in the discontinuance itself. So there is the discontinuance itself, which refers to it as a town road, public road, highway. And there's the declaration that the town came out in 2017. And beyond that, to require the applicant to go back.
It's a declaration based on what? I'm trying to understand, did anybody actually do the research to determine whether the town was laid out, or whether the road was laid out?
I can't tell you, Your Honor, back in 2017, although I was practicing, I had nothing to do with that. Attorney Slazen was going to be here, but he is not here. He may have been the town attorney at that time, I don't know. But regardless of what went in, with all due respect, Justice Dooley, regardless of what went into creating that document, what I'm saying is, as a citizen of the town and a landowner that's proposing a 2-lot subdivision on a well-traveled, appellants have a 9-lot subdivision, 6 of which are not even developed yet. So they're going to be creating a lot more use of this road than my client. That they should be able to rely on what the town says. If the town says in 2017, this is a discontinued public road and therefore everybody on it has a private right of access.
And Mr. Angel, nobody contests that the public road was discontinued, correct?
No one contests the discontinuance, but what the appellants say, Justice Waples, is that the road was not properly laid out.
Right, but
But they have no proof of that.
and if it is discontinued, a public road, then the abutting landowners all retain their private right of access under OKEMA.
That is correct. That is correct, Justice, and we stand behind that. And we believe that to be true.
What about the 400 feet? Am I wrong
I
about?
wasn't sure what Justice Dooley, sorry, Justice Freiberg, you were asking there.
I thought there was evidence in the record that it was 400 feet short of the project, of your client's project.
So there's a couple of things. The road itself, Old Cotting Road, is short of Westminster West Road because it hooks into McKinnon Road by about 400 feet. I was thinking maybe that's what you meant.
Yeah.
But Old Cotting Road goes well past the project. There's no 400-foot shortage there. As I believe counsel for the police said, it goes well beyond it. So I'm not sure what you're referring to there. I'm confused and I apologize.
No, I'm
But I don't-
confused.
I don't-
Let me just be clear. This case is not an image of tremendous clarity in either, in any.
Okay, well, our point is pretty straightforward, Your Honor. I do want to say just quickly, the town's position, there was a third part, is that they don't have to intervene. They're a party by right.
Yeah.
and they filed a proper.
Yeah, we got that. We got that. Your
So,
time is up, so thanks very much, counsel.
Okay, thank you, justices, and have a nice evening.
Thanks so much. And how about the appellant have any time left?
Appellant has no time remaining.
Okay, so call a conclusion of the hearing, please, and